Good evening. The hour of 6:30 p.m. having arrived, I will call to order this regular meeting of the Zoning Board of Adjustment. This meeting is being broadcast live on Spectrum Channel 1302. Anyone wishing to view a copy of the agenda and supporting materials will find it on the city website. To receive electronic copies of future agenda packets, please go to the home page and subscribe to the city meetings email list. The public and other Zoning Board of Adjustment members will be recognized to ask questions and make comments on the agenda item under discussion. After being recognized, all remarks should be made through the chair. Anyone who wishes to address the board is asked to go to one of the microphones in the room and identify themselves by name and address prior to speaking. Begin with introduction of the board members, beginning with myself, Josh Gorman.
Joe Hoppick, Vice Chair.
Jane Taylor.
Rich Clough. Michael Welsh.
Great. And then we'll move on to any minutes for the April 4th meeting. Do we have any comments? Attorney Taylor?
Yeah, I just have one minor, I think it's a correction. On line 95, which is on page 5 of 98 or page 3. Where it says, especially if it can be done in accordance with the latest zoning requirements is possible. I think that should read either as is possible or which is possible. I'm not sure. That's like a dropped word.
Yeah.
But that was the only thing I had.
Great. Anyone else? We have a motion to approve with Attorney Taylor's correction.
So moved.
All right. We have a motion from Michael.
Second.
Second from Attorney Hoppick. All of those in favor? It's unanimous. Any unfinished business?
Not at this time, Mr. Chair.
Great, thank you. So at this point, I guess we'll kick off the night. We do have quite a few agendas on tap tonight, so we'll try and move swiftly. Starting with ZBA 2206, where the petitioners, John B. and Judy Huslander Living Trust, represented by James Fippert of Brickstone Land Use Consultants, LLC, are requesting a variance for property located at 0 Belmont Ave, that's tax map 598-030-000-000. That is in the low-density district. The petitioner requests a variance to permit a building lot containing 5,625 square feet with 50 feet of frontage and 50 feet width at the building line of the low-density district, where 10,000 square feet lot size, 60 feet of frontage, 70 feet of width at the building line is required per Chapter 100, Article 3.3.2 of the zoning regulations. At this time, I'll call on city staff.
Thank you, Mr. Chair. So this property, just to start off with, just to make the board aware that the board needs to make a determination whether or not there's been a material change. This is a property that had received, or I should say applied for a variance back in 1988, which was denied at that time. So what they're bringing forth to you is really basically the same variance that was denied back in '88. There is, again, an allowance for if a material change has occurred for the board to hear this variance at this point in time. So we would ask for the applicant to present their case as to what the material change in this situation would be.
Great. Attorney Taylor?
Yeah, Mr. Rogers, we don't have a copy of what the application for the prior variance was. Could you fill us in? Was it solely limited to the lot size?
I certainly can. Thank you, Attorney Taylor. So the one from 1988, the variance was, again, to build a single-family dwelling on a lot that had the same square footage as it does today, the 5,625 square feet. At that time, the square footage required was 15,000, where today it's at 10,000. And they also needed to have 50 feet. We're only going to have 50 feet at the building line, where 80 feet was required at the time. Today it is 70 feet. So those were the variances. If you look at the request, it's going to be, the frontage is the only other one that's in addition to this is, they only have 60 feet of frontage where 70, I'm sorry, that's written, I'm sorry, I'm reading it wrong. And so it has 50 feet of frontage, so the frontage is the same. So it is pretty much identical. The only difference that we're seeing is currently in 88 where 15,000 square feet was required, where today it would be a 10,000 square foot requirement in the LD district.
Thank you.
You're welcome.
Any other questions for staff? Great, thank you. Mr. Fippard?
Thank you, Mr. Chairman. Jim Fippard. I'm with Brickstone Land Use Consultants, and I'm here tonight on behalf of the John and Mary Hulslander Living Trust. John Rogers did my job for me. He described what the material change was. It was a change in the zoning dimensional requirements that occurred in, I think it was 1986, actually, is when this zone change occurred. But they applied for a variance in 1988, which was denied, where 15,000 feet was required. And this lot is only 5,625 square feet. So the material change, which I believe is significant enough to justify hearing another variance application, is the change in dimensional requirement to 10,000 square feet. There's more history with this lot that you should be aware of as well. This lot was created in 1924. And in 1924, it was part of a subdivision that was approved. And I actually have a copy of it from the registry. And back in the good old days, when they subdivided properties, they would do slivers of land, 25 feet wide and varying lengths. In the area where Belmont Avenue was constructed, they did 112 of these lots, 25 feet wide. People would come in and buy 2, 3, 4, 5 of these lots and combine them, build a house. So, and that's how the neighborhood got developed. Belmont Ave was developed as a city street. The subdivision at that time called for other streets, Yale Street, Amherst Street, and Princeton Street, which were never constructed. They actually became lots in private ownership, or they became city-owned properties for possible future right-of-ways or for utility corridors. But back to my point, in 1959, the Hulslanders purchased 2 of the lots on Belmont Avenue, and they're outlined in red or pink. And they were lots 32 and 33 in the original subdivision. Back at that time, this property was zoned single-family residence, or the single-family district. And the minimum lot size was 4,000 square feet. So by buying 2 parcels, they exceeded the minimum lot size, and they had a valid building lot, a legal building lot. And then in the 1970s, when I started working in my business, there was another major zone change. And that zone change changed the minimum lot size to 10,000 square feet. They changed the name of the single-family district to low density. So low density required 10,000 square feet minimum, and they didn't have that. They had 5,625 square feet. They applied for a variance in 1980 to build a house on the property as it exists today, and that variance was approved by the zoning board. So when 10,000 square feet was the minimum lot size, the board made determinations that they met all the criteria and they were entitled to a variance. So then in the 80s, the change went to 15,000 square feet, which became such an extreme difference, the board wasn't comfortable in 1988, and they denied the variance application. So going back to the 10,000 square feet, I think is a significant material change that justifies rehearing a variance application.
Thank you. Any questions from Mr. Fippard? Attorney Hoppick?
Could you just explain one more time the dates of each of those 2 variances, the one that was granted and the one that was denied, and what happened to the one that was granted?
The one that was granted in 1980,
1980, okay.
yes. And back then, variances were good for 6 months. At the end of 6 months, they applied for an extension, which was granted. So that variance was valid for 1 year. They didn't have the resources at that time to afford to build a house, so the variance lapsed. It wasn't until 1988 that they decided to try it again, and at that time, the regulations were going in the wrong direction, if you will, depending on your perspective. It was kind of in the middle of my practice, and I saw the changes come about. People were reacting. They felt Keene was growing too fast and proposed changes to the regulations to slow it down.
And that
One
was
of the
the-
ways to do that was to create larger lots.
And that was when the 15,000 was in effect, is that
That's
what-
when the 15,000 came into effect, and I believe it was 1986. They applied in 1988 and were denied. And I did review the records, I reviewed the minutes of the meeting. The denial was mostly because they felt that lot size was so extreme that the community didn't want to go in that direction. They were going in the other direction, requiring larger and larger lots. And that was the major basis for the denial. And since that time, now we're in a period, the pendulum has swung the other way. So I've watched it go in both directions throughout my career. Now we're running out of building lots, we're running out of buildable land. We're recognizing that we need to make lots available at an affordable price so people can afford to stay in the community. We can have workers in our community. Our young people, our children can afford to buy a home or build a home and stay in the community. And there's been more and more pressure on the city council and the city of Keene to find ways to make that happen. So in my office, I'm seeing more and more applications for infill development, lots that were left over in subdivisions for whatever reason they weren't developed. Now I'm seeing those people come forward and let's try it. Let's see if this is the time to build on these properties. We're seeing more marginal land areas, steep slopes, areas with wetlands, get proposals for development. So the community's trying to respond. For the Holzlander family, they felt this is the time for them to come back to their lot, which they've held all these years, since 1959, paid all the taxes all those years on that property. It's too small to put in current use, so whatever is assessed for, that's what they had to pay on. So they felt now's the appropriate time. Given the history of the property, and I'm assuming I'm allowed to proceed now with the variance itself?
I think that the board would need to deliberate first
Okay.
and actually approve that it is a material change, and we will be voting on that. Attorney Taylor?
Yeah, I just have a question. And I guess my question is, does it make a difference to you whether this particular lot that we're looking at today, or whether the zoning provision required 6,000, 7,000, 8,000, 9,000, 10,000, 14,000, 15,000, does it make any difference?
It can make a dramatic difference depending on the property and where it's
No, we're
located.
talking about this property.
On this property,
Would you still need to come in for a request for a variance?
yes, 15, unless it dropped down below 5,625 square feet, we would need a variance.
Okay, thank you.
Michael?
Just a point of clarification, I think I've heard it in your presentation. Both of the variances, the one that was denied and the one that was approved, were heard before a board, a zoning board of appeals, as like ours.
The Keene Zoning Board of Adjustment.
Right. Thank you.
What makes this change from 10 to 15,000 material? I'm having a hard time getting my arms around that. And is there any cases on this? Because I didn't have any time to look up cases, so.
In reading them, I'm sorry, I didn't mean to cut you off.
You didn't, I was done.
Okay. In reading the minutes of the meeting and the testimony that was heard, the board, when 15,000 square feet was the minimum lot size, And that was adopted by the city council, created by the city council. That was the direction they wanted the community to go in. They just felt that at 5,625 square feet, it was roughly a third of the minimum lot size that they wanted to be created in the community. And they felt that that was too extreme. Now, at 10,000 square feet, we're a little over half of the required minimum lot size. And in looking further at this and looking closer at this, and this is where I was going in answering Attorney Taylor's question, depending on the lot and the lot constraints, it could make a huge difference based on the size of the property. Is it adequate to really build a single-family house and meet the other dimensional requirements in the zone? At 10,000 square feet, the setbacks are 10 feet on the sides, 20 feet in the rear, 15 feet in the front, and it is possible to build a conventional single-family home by today's standards on that property and still meet the dimensional requirements of setbacks and lot coverage. So in my mind, that's a major significance that would make this lot eligible to be built on, because it meets all of the other criteria other than lot size. So a homeowner living on this lot would just have a smaller lawn to mow, if you will, something I'm looking forward to now that I'm close to retirement. But
Just one quick question, I don't mean to interrupt, but I thought we were saying it needed 60 feet of frontage and has 50, right?
yes, that's the other parts of the zone dimensional requirements that it doesn't conform to. 70 feet width at the building line, 60 feet of lot frontage, and then
In the square footage.
10,000 square foot lot
But it
size.
meets your setback requirements.
But it can still meet all the setback requirements.
And has that changed? Would it have still met the setback requirements under the old zoning of 15,000 square feet? Have the setbacks actually changed?
I didn't look at that. I know I have it in my office because I kept all the old regulations over the years. So I don't know if John knows that.
Mr. Chair, I don't have that at my fingertips.
Okay. Any other points you'd like to make, Jim, before the board deliberates?
I think I'm done unless you have questions.
Great. Anyone have any more questions? All right. So I guess our order of business first and foremost is to determine whether or not we deem this a substantial change that actually does impact the merits of the initial decision. Attorney Taylor?
Thank you, Mr. Chair. I don't see a material change. The standard is set out in Fisher versus Dover, was that in order to consider it, the successive variance proposal either has to, one, demonstrate a material change in the proposed use of the land, or material changes in the circumstances affecting the merits of the application. There doesn't appear to be a material change in the use of the land. The question, I think, before us is whether or not the change in the zoning ordinance for the amount of land that will support a single, family dwelling unit, whether or not that affects the merits of the application. In my opinion, I don't think that it does, because whether it's 15,000 feet or 10,000 feet or 6,000 feet, you still have the same circumstances affecting the underlying merits of the application. I think what our job is to determine whether or not there's a material change. I don't see it.
Anyone else? Michael?
I guess when I'm thinking about it, not having been presented with any of the other factors that may be weighing in, setbacks or frontages or things like that, I look at the behavior of the two prior boards that have considered this, and the denial by the second board under circumstances when 15,000 feet was the minimum lot size is different than the approval of the board prior to that when it was 10,000. So I'm assuming that that is enough of a material change to warrant denial by one as opposed to approval by a prior. Us moving back to 10,000 feet, therefore, to me, seems like material change of the same sort, although in the opposite direction. So I guess I'm inclined to see this as a material change of the second sort that Attorney Taylor was talking about.
Anyone else? I would be inclined to think that based on the history of the property, that it was approved under 10,000-foot guidelines, similar to, not to repeat what Michael said, but it was approved in the early 80s with a 10,000 square foot minimum. It was not approved in the late 80s with a 15,000 square foot minimum, and now we're back to a 10,000 square foot minimum. So I think there is a pretty good case for rehearing this. We still have to treat it as a variance and walk through all the criterion. That would be the direction I would lean in.
Mr. Chair, can I ask if we can have any ventilation in here, because I'm about to pass out from the heat? I realize that's off topic, but
Well, we can't have you passing out.
No.
We've got 5.
Yeah, we need to wrap up.
Wait till about 10 o'clock tonight. Oh, that's better. Thank you, guys. If there's no further commentary, I guess we would take a vote on this. Attorney Hoppick, do you have anything to add?
I tend to agree with Attorney Taylor on the point of materiality, so,
Okay.
but I'm not going to, she stated the reasons fine, and I agree with that. But I see your point too, but I just don't think that one change is sufficient in material.
Yeah, I can see that point as well. Richard?
I can see both also.
Well, I guess we'll call to vote. I guess I'll make a motion. Do we need a motion, John?
At this point, Mr. Chair, I think we could do a straight-up vote, whether it meets the material change or not.
Right.
I think that would be, but a motion to that effect would be helpful.
Okay.
Well, keeping with the spirit of a positive motion, I would move that we find that there's a material change in circumstances, I guess is the way to phrase it.
Yep.
And a no vote would be against that.
Yep.
Okay.
So we have a motion to approve material change and rehear ZBA 2206 from Attorney Hoppick. I'll go ahead and second that. And at this point, all of those in favor? So it is 3-2. We will rehear this. So go ahead, Jim.
Thank you, Mr. Chairman, and thank you to the board. You've heard most of the history, which I put into the background in the application, and so I don't need to repeat that. But as a result of the zone changes that have occurred over the years, most of this existing neighborhood at Belmont Avenue and Colby Street has become non-conforming. And as I said, the subdivision was created in 1924. Most of the lots were purchased, and homes were built throughout the 30s, 40s, 50s, and 60s. So the neighborhood was really pretty well built out. Today, if you go up and down these streets, this is the last remaining vacant lot, and I outlined it in red on this plan, on Belmont Avenue. And the rest of the lots are all developed. So if you look at the dimensional square footage for each of these properties today, 68 of the properties are along Belmont Avenue and Colby Street, and they vary in lot size from 0.129 acres to 0.63 acres. 48 of those 68 lots are non-conforming due to lot size, so they're smaller than the minimum size required, even when it's at 10,000 square feet. I think there was only one conforming lot when it was at 15,000 square feet. So that's the character that's existing down here at this neighborhood. And that's very well established because the homes were built so many years ago. So I think that's important to understand, that that's the nature of the house lots on Belmont Avenue and Colby Street. So the first criteria is that granting the variance would not be contrary to the public interest. And I think, as I alluded to earlier, the public interest today, and this is the city of Keene in general, more than just the neighbors involved who don't want to see this lot developed. And I did get a copy of those letters that were submitted to the board earlier today. But the public interest is to make building lots available to members of our community. We need housing, we need affordable lots. Obviously, a small lot is more affordable than a 5-acre lot would be in the city of Keene. And that's going to enable us to build new housing and allow people and their children to stay in Keene, and to allow workforce housing to be created. This neighborhood is close by to Markham Corporation and the industrial park area off Optical Avenue. And so this was really created as a workforce housing back before we called it workforce housing. And I think it's in the public interest to allow a vacant lot within this existing neighborhood to be developed, and provided it can meet all of the other criteria that it's required to meet. And I'll be getting to that in a few minutes. The applicant in this case is proposing to build a single-family home on this lot, which is just under 0.13 acres, a little over 5,600 square feet. I want to point out to you that colored in green, also on Belmont Avenue, are 3 other developed lots exactly the same size. And the houses were built years ago. I did look them up on the tax cards. I believe it was the 50s and 60s where these were developed. And they were developed as legal lots at that time. They became non-conforming as the zoning ordinance changed. So, but it's important, I hope the board will recognize that lots of this size exist in the neighborhood, have been developed in the neighborhood, and to my knowledge have created no problems being developed at that lot size. What I was alluding to earlier in answering Attorney Taylor's question, does it make a difference, the size of the lot? It can make a difference. If there's a steep slope, if there's a wetland area on the property, if there's ledge outcrops, it can make a tremendous difference in the viability of building on a lot. This lot doesn't have any of those site constraints. It's a flat lot, level. It's sandy soils in this neighborhood throughout. City water and city sewer exists in Belmont Avenue, and it would be adequate to support another house constructed in this area. If the variance were granted, the spirit of the ordinance would be observed. If you read in your land development code under the low-density district, what is the intent of that district? The intent is to allow single-family homes, low-intensity development on lots with city water and city sewer. And that's exactly what this property is. It's a lot that can support a single-family house on city water and city sewer. And it can meet the setback and lot coverage requirements. So I think that this lot clearly meets the spirit of the ordinance as a low-density lot. Granting the variance would do substantial justice. Again, I want to point out when the lots were created and when they were purchased by the Hulslander family in 1959, it was a legal building lot. It became a non-conforming lot due to changes in the zoning regulations. So through no fault of their own, their legal building lot became non-conforming. That's why in 1980, they had to apply for a variance if they wanted to build a house. Unfortunately, they didn't act on that variance. It expired after a year and they lost it. So they reapplied, but again, the regulations had changed. And the second time, they were denied. So I think now that we're back to 10,000 square feet, it's the same situation where the variance was granted in 1980. I think it would do substantial justice to allow them to construct a single-family home on this lot. And number 4, if the variance were granted, the values of surrounding properties would not be diminished. I think if you recognize the existing neighborhood, all built out, there are 3 other lots exactly the same size with single-family homes created, that this lot can be developed with no significant effect on property values in the area. Now, there was a concern expressed by an abutter that if this became a rental unit and if an inattentive landlord wasn't paying attention, there could be a situation where property values could be negatively affected. If people living there weren't taking care of the property, they were acting out and causing problems. And that's not the intent here. The intent is John Hulslander wants to give this lot to his daughter Wendy, and she wants to build a single-family home which will be for sale. It will not be a rental unit that she's constructing in this location. So that's what I want you to be aware of as well. In 1990, Powers Appraisal was asked to take a look at the impact of putting a single-family house on this property, and they provided a letter at that time. I didn't turn it in as part of this application because I really didn't think I was going to need it. And I know you don't like to get information last minute, so I'm violating that policy of the board. But I do want you to have this for the record, that this was, and I think there's only 6 copies here, so if you and John can
Attorney
share.
Taylor.
Mr. Chair, before we can accept that, I think we need to vote under our revised rules whether or not to accept it.
Yep, I agree.
What was the year of that?
1990.
1990?
Yes.
Okay, so it's 30 years old.
It's a letter from Powers Appraisal.
Okay.
And I would ask the board to consider reviewing it, simply because nothing's changed. There have been no changes in the neighborhood other than these dimensional requirements, because it's a full built-out neighborhood. So there have been no other homes built, and I think the conditions that Mr. Powers reviewed are still in place today.
My inclination would be not to accept it. I think we're here, based on the fact, hearing this whole thing, that there's been a change in circumstances, and now we're being asked to accept some sort of documentation of old circumstances, which we're also being asked to overlook as not relevant now. So my inclination would be not to put it on the record. I don't think we can process it properly either. Go ahead.
Can we hear from Mr. Fippert at what we call in the law an offer of proof? What does the letter say? Just because I'd like to see the letter, because you think it's important enough to show us, and I'd be inclined to see it. I might give it no weight, but
Sure.
just a quick Reader's
Richard
Digest version
Powers.
of what it says.
Richard Powers wrote the letter.
Yep.
He was the owner of Powers Appraisal. He has since retired. But the conclusion of his letter, it's in large bold print on the second page of the letter, It says, "The placement of a modest home on the Hulslander property does not change the density or character of the neighborhood and does not cause a diminution of value to the neighborhood as a whole."
Attorney Taylor?
Thank you, Mr. Chair. I agree with you, Mr. Chair. I'm inclined not to accept it primarily because it's 30 years out of date. And having dealt with a number of assessors, there aren't too many that would be willing to approve of what they said 30 years ago without further investigation.
I don't even remember.
Yeah, that's true.
Yeah, I also just think the fact that Mr. Fippert has voiced how much things have changed since 1990 himself, there's too many variables to accept something 32 years old. Michael?
It looks like a long letter. And I think I'm inclined to go with the board. I think we can deliberate, make decision in the absence of official.
Okay, at this time, all in favor of admitting the letter? All opposed? It's unanimous. Thank you, Mr. Fippert.
Thank you for considering it.
Yep.
And thank you for letting me read his conclusion. So, what I do want to do in arguing about effect on property values is show you an example. This is a sketch that I prepared in my office showing the lot 50 by 112.5 feet. It's labeled on the plan. This is drawn to scale. And this is a single-family home, 24 and a half feet wide and 50 feet long. It fits, these are the setback lines, 10-foot side setbacks, 15 feet in the front, 20 feet in the rear. It fits easily within the setback lines. There's a driveway to what would be a single-car garage directly in from Belmont Avenue. I then looked at the lot coverage, and I included the lot coverage calculations on the page, so you can read them. You should have a copy of the plan in your packet. The total lot coverage is a little over 33%, and in the low-density district, 55% is allowed. So a single-family house on a lot that meets the setbacks, meets the front and rear setbacks. There's room for landscaping around the building, there's room for a driveway, and safe access into and out. As I said earlier, this is a flat lot, very level, good sandy soils, city water and city sewer. So I think a new home will not have a negative effect on property values in the area. And also, one of the abutters interestingly wrote in their letter that if this were a new home offered for sale, given the sale prices these days, it may raise property values in the area. And they were concerned that that would affect their taxes. So it's the opposite of the diminution in value. And I had to mention it, and I hope their property taxes don't go up as a result of this. But I think it would be an improvement, certainly to the property value on this lot, and I think it will have no negative effect on property values in the neighborhood. And I'll remind you that just down the street on Belmont Ave, 8 lots away, are 3 other lots exactly the same size. And I don't believe they have had a negative effect on the property values. The last criteria is unnecessary hardship. And I think that clearly a special condition was created on this property when the zone requirements were changed. And the city doesn't single out properties to do this to. This happens all the time as changes occur in zoning. In this particular neighborhood, this is the last undeveloped lot. So that makes it unique in the neighborhood. There's nothing on it, no building on it. And then the city changed the zoning regulations, which makes it impossible to them to do anything, any building on this lot without a variance. So I think that's a unique situation, that's a hardship that was the result of the changes in the zoning ordinances. Part 2, the proposed use is a reasonable one, and I won't repeat it all, but I think you saw that a single-family home does fit, does meet the setbacks, does meet the lot coverage requirements, and it can be an asset on Belmont Avenue rather than just a vacant lot. And I'll be happy to answer your questions.
Great. Attorney Taylor, you had one?
No, I figured it out.
Okay. I have just a quick one. This may be more for city staff, actually. In your site proposal there with the structure and the setbacks and all that, it's my understanding, and maybe it changed in the new zoning code, and forgive me if it has, but that parking needs to be behind the front line of a house? Is that no longer in effect, John?
If I may, Mr. Chair, there's two options. One is it would have to be behind the front setback.
Great.
And then if a building if a building actually, a lot of our older homes actually sit within that front setback, that's where that front building line parking requirement comes into play.
Perfect, thank you. Anything else? Michael?
Just curious, I realize that we got letters from neighbors on this case this afternoon, emailed to us. Does the same situation apply to admitting those letters as part of the record as the letter that Mr. Fippard was?
I believe the way that it's worded is the applicant has a deadline for submittal, but people contesting or supporting the application do not. John?
If I may, I think the chair is absolutely right, and it obviously at times, a lot of times we will see the letters when people are not able to make the meeting. I'm not saying that these abutters aren't here tonight, but we see these quite often and historically accept the letters in support or opposed.
It will be my intent to, when we get to the public portion of this, to read those letters into the minutes. Anything else? All right, Jim, I guess that's it for now. Thank you.
If I could just add a clarification. Mr. Rogers mentioned that if you can park behind the front setback, which is this dashed line here.
Yep.
So there is adequate room on the property and in the garage to park well behind that line on the lot.
Great, thank you.
Thank you.
Yep. Attorney Taylor.
I'm sorry, I just thought of something. This 24 and a half by 50 proposed dwelling unit, how many bedrooms is that?
The actual house isn't designed. If it's a single-story ranch, it's probably a two-bedroom house. If it's a two-story or a Cape-style building, which it could be, there would be room for 3 bedrooms.
Yeah, I was asking the question because it struck me, I can't tell from the drawing, what the distances are of the driveway, but unless I'm missing something, which is possible with the new land use code, you would need to have 2 parking spaces, one of which, of course, could be in the garage. But how long is that driveway?
This
Is there,
drawing is to scale. It's a 10 scale. And I happen to have a scale with me.
am I right on 2 parking spaces?
If I may, Mr. Chair. Yes, absolutely. Attorney Taylor is correct that a dwelling unit would require 2 parking spaces, depending on, again, I would just stress at this point that this is just a proposed, what we actually, if this were to be approved and a building permit were submitted, it could be something totally different. But I would also just make it clear that behind the front setback, you would need to have 18 feet in order that to be really considered a parking space there. Or the parking spaces could be the garage spaces if they built a 2-car garage underneath the structure.
Thank you, Mr. Chair. The front of the building, or the entrance to the garage, is about 27 feet behind the front setback line. So there's more than adequate room. There's also room to widen the width of the driveway at this location. You could have 2 cars side by side. This is 12 feet wide, the way it's drawn, and you can have room for a car in the garage.
Great. Thank you. So at this time, I guess we'll just call on the public. Thank you, Mr. Fippard.
Thank you.
And if we have any post-commentary from you, we'll call you back up. But at this time, we'll call on public input, first beginning with anyone who may be in support of this. Seeing no takers, I'll offer it to anyone who is against it. I see a hand in the back. Come on up. Please just state your name and address for the minutes.
My name is William Hope. I live on 43 Belmont Avenue, across from said lot, pretty much. I don't see any problem with John building a house there. That's all I got to say.
Great. Thank you. Anyone tonight here in opposition of this proposal? Not seeing anyone, so at this time I am going to read those letters into the minutes. Corinne, do you have copies of those? Oh, okay. And then, okay. Okay. So I do have 3 letters, but they all have very similar material content. Actually, it appears as though, John, 2 of them are the same. Is that correct? And one of them is...
That's correct, Mr. Chair. 2 of them have the same, all 3 of them actually have the same bullet points as, I think,
Okay.
as to what the writers were trying to get to the board.
So I'm going to go ahead and read one of them in. They all make the same, I guess it's 5 material points, bullets, if you will. They are from 3 separate people. And one of these folks also submitted a handwritten note, which I'll read in first, and that's more relative to material change, which the board has already voted on. But with that said, members of the zoning board for ZBA 22-06, we went through this years ago. The lot size has not changed since then, and it's still small for zoning requirements. Why are we doing this again? Sincerely, that's from Dennis. Sorry, I'm having trouble with the last name. La Chanel. Forgive me if I've mispronounced, and he is a resident of 29 Belmont Ave. Then on to the letters in opposition, again covering all 3, and they are from Sally Luxkovich Houghton of 37 Belmont, also in Keene, and Dennis LaChanel and Sandra LaChanel of 29 Belmont Ave in Keene, and we have Lucy Truslow of 21 Colby Street. And they make the following points. I'll just read it from start to finish. I'm writing an agreement with the other abutters to 0 Belmont Ave to share my concerns regarding the request for variance by John B. and Judith A. Husslander Living Trust to build a home on this lot. My objections to this request to build a house on this property are as follows. The size of the lot does not conform to current zoning requirements. Construction of a house will cause long-term disruption to the existing neighborhood. Plans for the building do not indicate number of floors. This house might be built for immediate resale of the property, thus raising the value and having an impact on neighboring tax levels, or it could be used for rental purposes, lowering the value of neighboring homes. Those who live opposite and adjacent to this property want to keep the space open to avoid overcrowding and retain the aesthetic sense of open space in the neighborhood. So having said that, if Mr. Fippert, if you'd like to come up and rebut those comments, you're welcome to do so.
Excuse me, Mr. Chair, did you read all 3 of those?
No, as I said, all 3 of them say the same thing.
But if you don't read them, they're not officially in the record over the names of the people who sent them.
Okay, I'll read the same thing again then. Letter 2, I am writing an agreement with other abutters to 0 Belmont Ave to share. Can we just put the same thing that I just read into the minutes?
I mean, I would, the fact that you mentioned all 3 of the letter writers' names and their addresses, that put that in the minutes, and the fact that you're stating that the bullets are all identical, Again, it looks like it was very much somewhat of a template that was handed out by someone, because it's almost the word for word, at least the bullets were.
Yeah.
But I would leave that for the board to decide.
I'll just read them. So this person is saying, this is actually a photocopy of the letter that I just read, but it says that I am writing an agreement with other abutters to 0 Belmont Ave to share my concerns regarding the request for a variance by John B. and Judith Hustle Living Trust to build a home in this lot. My objections to the request to build a house on this property are as follows. The size of the lot does not conform to the current zoning requirements. Construction of a house will cause long-term disruption to the existing neighborhood. Plans for the building do not indicate number of floors. This house might be built for immediate resale of the property, thus raising the value and having impact on neighboring tax levels, or it could be used for rental purposes, lowering the value of neighboring homes. Those who live opposite and adjacent to the property want to keep the space open to avoid overcrowding and retain the aesthetic sense of open space in the neighborhood. On to letter number 3.
Mr. Chair,
Yes.
I raise the point because I think members of the public deserve a little bit of respect in having their comments read into the record,
Right. That's what I'm doing.
respectfully.
As noted, the size of the lot does not conform to the current zoning requirements. I understand that there are 3 other similar sized lots with homes on them on this street, but that they were built prior to those current zoning requirements. Plans for the building do not indicate the number of floors. Construction of a house could have long-term disruption of the existing neighborhood. Will this house be built for immediate resale of the property, thus raising the value and having an impact on neighboring tax levels, or might it be used for rental purposes, possibly lowering the value of the neighboring homes? Those who live opposite and adjacent to this property want to keep this space open to avoid overcrowding and retain the aesthetic sense of open space in the neighborhood. Recognizing the burden of paying taxes on a non-conforming piece of property, if the petition fails, I would be willing to consider purchasing the land at its appraisal value of $3,600 to keep it as open space, adjoining my property at 21 Colby Street, depending on the amount of annual tax paid for it. And that is from Lucy Truslow. Mr. Fippert, go ahead.
Thank you, Mr. Chairman. And I'm actually glad to see people take the time to express their concerns to the board. So many times I come in here and there's no public input. It's just a lot different than it used to be. I think I've been doing this too long. I've answered, I think, the first 4 criteria or questions or concerns already. And I want to make a comment regarding the last criteria, that those who live opposite and adjacent to the property want to keep this space open to avoid overcrowding and retain an aesthetic sense of open space in the neighborhood. I think if I lived next to this lot, I too would want to keep it open. That's just our nature. We enjoy the open space. We enjoy the sense of space where we live, especially if you're out in the yard and doing different activities to enjoy your property. You don't want to have to fence in your property to maintain your privacy. So I understand that. But at the same time, I don't think it's fair to a landowner to lose their rights to use the property if they can comply to the dimensional requirements, if they can use it in a way that maintains the character of the neighborhood and maintains the sense of space in the neighborhood. And I think this proposal does that. So I hope you don't agree with that last concern, because I think that's just an injustice to the property owner. And I'm hoping you can grant the variance and allow this to proceed. Thank you.
Thank you. Any questions? Go ahead, Attorney Hoppett.
Mr. Fippert, what other reasonable use could this property be put to in this area?
It's funny because I discussed that earlier prior to the meeting with John Rogers. If you look at the list of principal uses, it's not a long list in the low-density district. Single-family residence is the primary use. A small group home, but it's subject to a CUP, which is a special planning board permit. Difficult to get depending on the circumstances. And then a community garden or conservation area. A 0.13 acre lot is not a significant land area for a conservation parcel. Most conservation parcels in the city of Keene are very large tracts of land or adjacent to other conservation areas, creating a significant resource for wildlife habitat, for recreation, for passive recreation, hiking trails, those types of things. So this property, I don't think is appropriate for that. Community gardens, again, it's such a small lot. I have a garden behind my house, vegetable garden, actually 2 gardens, which would just barely fit on this lot. And I don't think as a community garden that's realistic. So I think single-family home is the only reasonable use for a property like this, especially where it's in the middle of an existing single-family neighborhood. And I hope you agree with that. I hope the board recognizes that. And the only way they can do that is through a variance.
Okay. Anyone else? Thanks, Jim.
Thank you.
This time I'll close the public hearing. Board begin deliberations, beginning with criteria number 1, that granting the variance would not be contrary to the public interest. Go ahead, Michael.
I'll just reiterate what I have seen from the applicant, in that there does seem to be a short supply of building lots in the city of Keene, and it does seem to indicate that the public interest is in finding building lots. Also, from the last master plan, I know that there was an emphasis, because I was on the committee that put it together, to encourage infill development, to look for, small parcels of land that could possibly be developed, and that was considered to be a good thing. And so I will come down on the side of this being in the public interest.
Go ahead.
Yeah, and I'll provide some counterpoint. In that not every square foot of land is appropriate for construction or infill. And paving paradise and putting up houses isn't necessarily the way to go. Just because it's there doesn't mean it's appropriate.
Is it okay?
Oh, yeah,
This
sorry,
is,
go ahead.
this appears to be a case where it's a classic illustration of the relief valve that we're supposed to exercise when we grant a variance. Somebody's owned this property longer than I've been alive, 1959, 1 year longer, paying taxes on it. Had an opportunity to develop it. For whatever reason, and I don't hold that against them, they didn't. Their variance expired, and they're back again for the second time in 30 years. I don't see this as a single-family dwelling, that is, as a use that will alter the essential character of this neighborhood, nor is it a variance that would threaten the health and safety and welfare of anyone. So I think the first 2 criteria are met, and I'm pretty persuaded that the rest of them are as well, but I can speak to that separately. And I asked Mr. Fippert about what other uses are there in this zone for this property. A community garden is not realistic. That's not what a property owner expects when they exercise their right to buy property and own it and have it protected from unreasonable, denials of reasonable uses. So I think a variance is in order in this case.
Great. Anyone else? I would be inclined to agree with Attorney Hoppick. I think that this is in likeness with the neighborhood. I think the concerns voiced by abutters are not really valid, in that any house in Keene could be rented. You don't need to tell how many floors you're going to build a house if the house is a reasonable use. I just think that if you go down Belmont, this is going to be pretty consistent with what's there. It has city water and sewer. There's not going to be safety issues or traffic issues created by this. It's going to be a single-family home tucked amongst other single-family homes, all on very similar lot sizes, as Mr. Fippert illustrated and articulated. So I am inclined to favor this variance application. Anyone else?
Are you going through the criteria?
Yeah, I was speaking primarily to 1 and
Okay.
2. We can move on to, do you want to hit number 2? Attorney Taylor, do you have commentary for number 2? Moving on to number 3, that granting the variance would do substantial justice. Go ahead, Attorney Hoppick.
Yeah, I'm having a hard time seeing what the gain to the public would be if this variance were denied. And the loss of the individual owner, I think, is significant because these people have not had an opportunity to develop their land in any fashion. Aside from the instance in 1980. So I'll take that back to a degree, but I think this substantial justice requires that the individual loss here is going to be significant and not outweighed by any gain to the general public by leaving it the way it is.
Anyone else? Attorney Taylor?
Yeah, I don't know what criteria this comes under, which number. But I guess one thing that kind of bothers me is that when you buy 2 adjoining lots, you don't, I mean, we haven't heard any testimony from the property owner, but I have no idea what the sort of development potential thought process would have been on the part of the property owner. So it's kind of a little bit hard to judge the substantial justice portion of it, because we just don't have any testimony as to what the intent of the property owner was when the property was purchased. I mean, a number of these, I don't know if any of them have been merged. Some of them look like they were probably purchased together maybe and then combined to build a house on. I don't have any idea. So I think we have a complete lack of information on that particular criteria.
Am I correct in understanding, though, Attorney Taylor, that this was a building lot back in 1959, even, and met zoning criteria at that point? Is that your understanding?
It may have been, and it quite possibly was, but that, I'm not sure if that's completely relevant today.
Anyone else? So moving on to number 4, if the variance were granted, the value surrounding property would not be diminished. Go ahead, Michael.
I think I've heard evidence on all sides of this one, from the quick description of the letter from 1990 to the testimony of the abutters indicating property values would go up and property values would go down, all of which presumes the development of the property. I think it's also reasonable to wonder what happens to home values if the property isn't developed, and we've looked at a number of cases over the past couple of months looking at vacant lots that weren't very well cared for and that were seen as diminishment of the surrounding properties, which is a trajectory this property could go if it stayed vacant. So I don't think we've got much evidence that it's going to do bad things to property values. And I guess if I had to come down on one side or the other, I'm guessing it would be consistent with the neighborhood and a plus, if not just a break even on property values.
Great, thank you. Attorney Hoppick.
I would add to that if the owners carry out their plan, which is the construction of a single-family residence, Cape style or one a ranch style, I think I heard two styles mentioned, whatever, either one, odds are very significant that they would enhance the values of that area, immediate area, including their own. So I'm persuaded that that factor is met as well.
Great. Anyone else? Moving on to number 5, unnecessary hardship, and that is 5A, that owing to special conditions of property that distinguish from other properties in the area, denial of variance would result in unnecessary hardship because no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of that provision to this property, and that the proposed use is a reasonable one. Attorney Taylor?
I'm probably in the minority, but just to echo what Mr. Walsh said a few minutes ago, we are consistently seeing requests for variances on properties that are too small to develop in the zones in which they exist. I did take some more time this afternoon to go through some of the past case law, and I think what they say in summary, going back since before the first time this thing had a variance, was the important first criteria: is the property unique in its environment? I think Mr. Fipper demonstrated very well that this parcel is not unique in its environment because, and I can't remember the number of parcels, 68, something like that, but there are not just those 3 other parcels of the same size that he pointed out, but there are many, many parcels in this area that don't meet the current standards, whether or not they're built on or not. So I guess my point is that as a threshold issue, I don't find that this particular parcel of land is unique in its setting. And the case law supports that by saying just because it's not, doesn't have something, whether it's a building or the original case, a garage, if it's the same size as all of the other lots in the area, it's not unique. So, that's where I come down on it, and I think that we should apply the appropriate standard and not just approve everything because, gee, it's the only vacant lot around. So, thank you for letting me have a minor rant.
Anyone else? Attorney Hoppick?
I disagree, but only slightly. I think the lot can be claimed to be unique because it is undeveloped. It can be built within the confines of the setbacks and the side and front setbacks and whatnot. And I'm not sure about those other 3, if they're in variance to those measurements either, but that might be useful to know. But I think that unique setting of the property and the fact that there's no other reasonable use for this piece of property is what is bothering me. And I'm happy to condition approval on the construction of a single-family residence just to assuage fears about what would happen to it, but because I think that overall fits right into this neighborhood. A home the size of the home that Mr. Fipper described particularly.
So when I come to number 5 and Attorney Taylor's points, which I do agree with, that this lot is not unique in size. I believe it's unique in vacancy. I think it can be concluded that 5A Part 2 is met, that the use is reasonable simply because it exists everywhere around it. So if it wasn't reasonable at one point, it certainly is now, given that it's going to be the same as everything around it once it's developed. The 5A, Part 1, is a little more difficult in terms of uniqueness, but the 5B, special conditions that distinguish from other properties, I think is pretty easy to see. All the other properties have been afforded a use. This one is not. So I understand that case law probably does, side with what Attorney Taylor was saying, but I also think that there's ample and adequate case law that a property be granted some form of reasonable use, and I think that that would probably go further than a community garden. So with that said, 5B, I think this property meets, in my opinion. Attorney Taylor?
Yeah, just briefly, that's, goes back to what's called the Gray Rocks decision, and frankly, what comes first under that is that the land be unique, but also that the hardship is not the result of some unique condition of the land and not the personal circumstances of the owner. And I think that this is the personal circumstances of the owner, so I don't feel it comes within 5B either.
Okay. Anyone else? Is the board ready to make a motion? Do I have a motion? Attorney Hoppick?
I would move to approve ZBA 22-06 with one condition, that only a single-family residence be constructed on it.
Second from Michael. We have a motion from Attorney Hoppick, second from Mr. Welsh. At this point, we will vote on the 5 criteria and then come to a final vote. Beginning with number 1, that granting the variance would not be contrary to public interest. All those in favor? 4. All opposed? 1. Number 2, if the variance were granted, the spirit of the ordinance would be observed. All in favor? 3.
I'm in favor.
All right. All opposed? It's 4-1. Number 1 was 4-1 as well. Number 3, granting the variance to do substantial justice. All in favor? 4. All opposed? To 1. On to number 4, if the variance were granted, the value of surrounding properties would not be diminished. All in favor? It's unanimous. On to number 5, A, and that is unnecessary hardship, that owing to special conditions of the property that distinguish from other properties in the area, denial of variance would result in unnecessary hardship because no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of that provision to the property, and that the proposed use is a reasonable one. All in favor? It's 3. All opposed? 2. And I'm going on to 5B. Explain how if criteria in subparagraph A are not established, an unnecessary hardship will be deemed to exist, and only if, owing to special conditions of the property that distinguish from other properties in the area, the property cannot be reasonably used. So I am voting actually in favor of 5 based on B. So again, to hold the vote on 5, unnecessary hardship, all in favor, all opposed, it's 4-1. So final vote on ZBA 2206, all those in favor, 4, opposed, it's 4-1. Thank you, everyone. At this point, we will move on to ZBA 22-07, and that is where the petitioner White House Group, represented by Jim Fippard of Brickstone Land Use Consultants, requests a variance for property located at 441 Main Street, Keene, tax map 112-020-000-000. That is in the low-density district. The petitioner requests a variance to permit a personal service establishment in an existing building in the low-density district where a personal service establishment is not permitted use per Chapter 100, Article 3.3.5 of the zoning regulations. At this time, Michael?
Mr. Chair, as my employer is in a butter, of the property in question here, I'm going to recuse myself.
Great. Thank you. Is the petitioner aware, still wishing to move forward with this application?
I was made aware that Mr. Welch would request to recuse himself. I don't feel it's necessary, but we wish to proceed with 4 members.
Great, thank you. So at this point, I'll call on city staff.
Thank you, Mr. Chair. So this property, 441 Main Street, you can see on the monitor, is on the corner of the lower part of Main Street and the highway system where Route 101 and Route 12 come together in the city. It is in the low-density district, and sorry, lost my train of thought there for a second. This property did actually receive a variance back in 1984, at that time to allow for professional offices only, and they specifically, with the approval, there's been some different uses that were called out, and I'll read this to you. It says that there shall be professional offices only, provided the occupants are of low-intensity uses, including but not limited to attorneys, architects, engineers, doctors, insurance agents, dentists, accountants, and the real estate office of the owner, but excluding such traffic-generating uses such as travel agents, beauty salons, etc. That is why the application is before you. Under the older zoning code, some of these uses were, especially with travel agents and possibly beauty salons and such, sometimes were considered professional offices, since a lot of them were by appointment only and licensed by the state in most cases. But the board at that time certainly felt the need to condition that approved use. Since then, the new zoning code, we have called out, and under the professional care definition, is a new use to make sure that we're not just trying to sometimes scratch our head and try and figure out what some of those uses are. So currently, the personal service establishment is defined as an establishment that provides services of a personal nature, including but not limited to barbershops or hair salons, spas, nail salons, laundromats, dry cleaners, tailors, tattoo, and body piercing parlors. That is why the applicant is in front of you tonight, is because what they're proposing was specifically called out in the previous variance that was granted.
Attorney Taylor?
Yeah, I think I'm now confused. So the original variance basically excluded some of the uses that were considered personal service. And the new code includes a very broad definition of personal service. So I guess my question is, if we were to approve a variance that allowed a personal service, that would be much broader than this specific request? Is that correct?
Again, the request is for the personal care services, and that is, as the attorney just touched base on it, is a pretty broad definition that does bring in a lot of different. I guess previous code might have spoken to them more as a retail service type thing. It's not just straight up retail, but it's a retail service. But the current definition that the applicant is seeking a variance to allow to occur is a pretty broad definition. Yes.
All right, so I guess, Mr. Chair, it might be appropriate later on if we might want to consider some conditions.
Sure.
Thank you.
You're welcome.
Mr. Fippard, welcome back.
Thank you, Mr. Chairman. Jim Fippard on behalf of White House Realty, or White House Group, I'm sorry. And this is the property at 441 Main Street. You all know it. It's the big white house. It sits on the hill as you're coming into Keene. It's pretty well considered a historic gateway property to our city. And this variance that was granted in 1984 was very important for them at that time. The building, it's a very large building if you consider it a single-family home with 5,000 square feet of space on the first and second floors, but also there's a 2,000 square foot basement area. So it's just even by today's standards, where some McMansions are being constructed, especially on the lakes, this is a big house. This is a big building. In 1984, they came before the Keene Zoning Board of Adjustment and got relief to lease out professional office space in the building. And the debate at that time, and why it's described as professional office space, was they wanted to limit the uses to low intensity. And I agree with Attorney Taylor that if you can grant a variance, a use variance in this case, it should come with conditions. And we're not trying to throw away the previous variance that was granted, we're trying to respect it. And we think that over time, the occupations have changed and our definitions have changed. We didn't have a definition for a personal service establishment back in 1984. And I don't know that it would have changed the result at all. But it came out of the development of the Land Development Code. And I wasn't even aware of this definition being added until John called it to my attention. So the request specifically before you is to allow a professional use. In this case, I cited an esthetician, and I had to look it up and talk to some people exactly what it was. But the operator specializes in things like facials, lip treatments, eyelashes, eyebrows, pretty much centered around the face. But it also should include a cosmetologist, and it's a similar profession. They're both required to be licensed in the state of New Hampshire. And back in the 80s, when we argued about what was a professional office space, that was usually the first thing we cited. They should be licensed. Shouldn't be just somebody opening an office. But by being licensed, that tends to restrict the business to appointment-type businesses where people call. You don't just walk in off the street. And it wasn't meant to include retail-type offices. And that's why they were so specific, and I included the copy of that approval back from 1984, because that's what introduced this controversy, if you will. So we're asking for permission to allow professionals like an esthetician and a cosmetologist, provided they're licensed professionals, that they operate as sole proprietors. So this isn't a beauty salon with 6 or 8 chairs and providing multiple services at the same time, and a lot of activity that wouldn't be appropriate in what's an existing residential neighborhood on that section of Main Street. So I think it is appropriate to have a condition that restricts this to sole proprietors, business by appointment only, and no walk-in service or retail-type service. So I'd like to start out by pointing out the property. I did provide an existing condition plan. We're not proposing to change anything on the site. There are 18 parking spaces existing on the property. If all of the usable area for offices are used at 1 per 250 square feet, 16 parking spaces would be required. So the existing site is an appropriate site for professional offices with the limited uses, and it does meet the current parking requirements. The first criteria is that it would be not be contrary to the public interest. And this is where part of the history for this property comes into play. It was deemed appropriate by the Zoning Board in 1984 to allow professional offices in this building, and they found it to be in the public interest, and I agree with that. But since the pandemic started, so much has changed, and the way people do business has changed. And more than most other businesses that I work with or work for, this property was affected more than most. This building, after 1984, the variance was granted. This building became occupied primarily by therapists, psychotherapists, physical therapists that operated by appointment only, licensed by the state of New Hampshire. And it's worked very well since 1984. You don't see cars parked on the side of the road. You don't see cars parked on the lawn. They're respectful of the property, and it served the property very well. But with the pandemic, all that changed. The therapists quickly learned that they could provide their services by Zoom meetings or other online meeting venues, and they didn't need the physical office space to continue to see clients and offer their counseling services. So one by one, the offices in the White House were becoming vacant. J.R. Coughlin Real Estate is the principal occupant of the building. They have been, they own the building all along. That's why they were mentioned, not by name, but by profession in the approval in 1984. And they continue to operate that space in the building. But as realtors go, he's really a specialist. He doesn't have a dozen realtors working for him. So it's not the large retail type real estate office that you might see at Mazziello or Remax. And so the use has fit, and it fit that main restriction that was developed in the previous ordinance. And I think that it is in the public interest to allow other professional office uses, as I've described them, sole proprietors, appointment only, licensed professionals in the state of New Hampshire in the building, and that fills a need in the public. So an esthetician, a cosmetologist, where one person can make an appointment, occupy the space for up to 2-3 hours at a time. There's not a lot of turnover, not a lot of activity, and our new definitions of personal service establishment, I don't think are fair to people like that are operating as a sole proprietor under those conditions. But you can address that in your conditions. If the variance were granted, the spirit of the ordinance would be observed. And in this case, I think the spirit here is best addressed by the conditions of the 1984 variance. And we think that the use, as I proposed it to you, fits very nicely under that condition with those conditions in place. So I'm not asking you to open this up to all personal service establishments. I think they do need to be restricted, and that's appropriate, especially on this property. And that would meet the spirit of the ordinance. The third criteria is substantial justice. And I don't see any value to the public for you to deny this request. So what benefit to the public would it be to not allow a sole proprietor working by appointment only in an office space in that building? I do have to admit to you that there are existing users in the building that fall under this definition of a personal service establishment. And how they get in there, I don't know. If they slip through the cracks, they obviously didn't come in and ask code for permission, but they were sole proprietors, professionally licensed, working in the building by appointment only. And it's worked very well for the last 2 or 3 years. As the therapists left and these people came in, there have been no disruptions, no disturbance to the neighborhood, and no excessive parking or noise created. All of their activities are conducted inside the building, and I think that's what helps make this work. So I think it would accomplish substantial justice, especially for the owners of the building, to allow these types of tenants, because these are the people looking for these spaces. It's a single room or 2 rooms in the building that they occupy, but again, a single employee in business by appointment only. And the values of surrounding properties would not be diminished, and I don't have to repeat all that. They've been doing it successfully at the site, very quietly. They don't exceed the number of parking spaces required on the property, haven't created any disturbances. Unnecessary hardship, and I won't read the whole thing to you, but because of the size of the building, in 1984, the zoning board agreed this is a special condition for this property that results in a hardship to a normal residential use, as you'd see in a low-density district. Therefore, they granted the variance to allow these offices. Where I want to vary from the previous approval is to include the uses under a personal service establishment under the right conditions. So sole proprietor, so a single employee in the building, appointment only, and licensed professionals. So I think that protects the character of the neighborhood, it protects the character of this property, and it fulfills the requirement that was imposed in 1984 under the original variance. I think that I don't need to go through the rest. I think those uses, as I'm proposing them, are reasonable. They're not going to increase traffic, they're not going to create excessive noise, and they won't have any effect on the surrounding properties. So I hope you can support this request.
Attorney Hoppett?
So, Mr. Fipper, just to, I guess a point of clarification is my question. You're interested in a variance to allow a personal service business so long as they're a sole proprietor, they're by appointment only, and they're licensed by the state?
That's correct.
So those are three conditions you would invite us to adopt?
I invite you to do that.
Okay.
Jim, you mentioned uses right now going on that are similar to what you're requesting. What has provoked the application, if it's already happening?
I think it came about because someone approached code about a form that's required for licensing by the state of New Hampshire, and that made them aware that this use is taking place on the property.
Great,
So I'm trying to correct that situation.
great, thank you. Attorney Taylor?
Thank you, Mr. Chair. The original conditions, first of all, they said there's no parking on the north side of the property. Is that those 3 spaces are not supposed to be used?
And J.R. Coughlin is here with me tonight. I really don't know the history of those 3 spaces, but when I went out to do the existing site conditions and I saw those spaces there, he does restrict the use of them to his office. And his office is gained access from that side of the building, so it's not really open to the public. And they probably pre-existed the condition from the zoning board, but maybe J.R., if you don't mind, J.R. can come up and help me with this one.
My name is J.R. Coughlin, and I own the property at 441 Main Street, Keene. And I guess the question is, who has the parking on the north side?
No, excuse me, the question was that the conditions of the 1984 variance said there was not to be any parking on the north side of the building.
Yeah, we let the neighbors park there. There's a rental property across the street, and sometimes they'll park on that property, but with our permission. But right now, it's for, I think it says oral deliveries, and what was the other one we had? Rubbish pickup. So I'm trying to answer your question.
Yes, go ahead.
I guess my question is now for Mr. Rogers. I'm in a bit of a quandary if that was a condition of the original approval and it's not being observed.
I would look at this, and if I may, Mr. Chair, I would look at this and think that that's a restriction on that parking to be, not to be for the variance of the professional offices, but again, if it was allowed for, again, other tenants that already were existing in the building. I would also just caution the board, this is a prime example of a condition that's been put on a piece of property, the variance that try and enforce. So moving forward, if the board were to condition this variance or others, certainly that's a good,
Well-
this is a good one to keep in the back of your mind, because this is one I'm not sure how you would enforce it, or how do you even initially interpret it, but I would interpret this to mean that it was meant for either the real estate office that's there, the owner of the building, and/or if they have an agreement with the abutting property to use those spaces.
Well, yeah, it's ambiguous at best. So I guess my follow-up question is the intent of your application to essentially keep the existing conditions intact?
Yes, and my intent is to allow the occupants of the building that are there today to remain, and to specify more clearly what this personal service establishment use can be with the right conditions.
Would you have any objection to us clarifying the parking so that because this is so broad and so squishy?
Yeah,
To say something to the effect that, the parking on the north side of the building is limited to the building owner or something like that.
and not to be used by occupants of the professional offices.
Yeah, just something to keep down the traffic on that side of the building, which seems to be part of the intent.
I think it is, and I think you're right, it was ambiguous the way they listed it. Simpler times back then, I guess. But if you look at the site, access to those spaces is by a separate driveway,
Right.
which if you drive down there, it looks like the driveway to the house next door, and it is. And if you observe the traffic going to the existing office users in the building, they all turn through the front and park in the area adjacent to King Court. So I think they're practicing what the intent was, but maybe a
But
clarification, as you
clarification.
suggest, would be.
And the only other
Appropriate.
comment I think I have is on your comment about sole proprietors, in that also might have an enforceability issue, and there are so many different kinds of legal entities out there that it would be virtually impossible to try and limit it to somebody who wanted to have an LLC, and yet they were only one person or whatever.
My intent was to allow one employee in the space, and not a business with 3 employees that can operate at the same time. It would be a single person operating a business in that office.
Would it be more aptly put to say that it would just be a single member operation? That way, Attorney Taylor, it could be a single member LLC, it could be a sole proprietor, it could be, but
Professional corporation.
Yeah, I'm
yeah,
okay
but
with that.
you're more referring to just the fact that this is not a situation of 8 employees, rather one professional who is making appointments. And that's a condition that you'd be satisfied with.
Yes.
Great. Anything else? Go ahead.
Yeah, and this is probably for discussion later, but I'm also still a little bit concerned about, although I think it's apt to say that they be a licensed professional, because, beauticians and hair salons and barbers and all that, they have to be licensed as well, so not quite sure how to limit it, but I understand the intent.
Any commentary on that, Jim, or
No,
Are there
I think
any
she
u-
explained it.
are there any uses that you have in mind that would not be licensed or that are existing?
I'm not licensed. I'm a sole member LLC, but I also have 2 employees. And I don't think I would fit.
Yeah, but you're not providing the type of service that we're alluding to here.
Well, that's true, but I don't think I would meet the intent of this as well. I'll have meetings at my office with 8 or 10 people attending, and they all come in separate vehicles, and It can get quite busy at times, and other times it's just me and my wife. But I think this is pretty specific, and I hope you've all had a opportunity to visit that property at some point. It's worth a visit to go in, and I've only been in a couple times in my life, but the high ceilings and the architecture that's all preserved in that building, the beautiful doors and the woodwork, it's just incredible to see, and it needs to be protected and preserved. And J.R. and his family have done a wonderful job taking care of that landmark property for our city. So I think by restricting this use, the way we've described it, that continues that protection for that area. So the parking doesn't get expanded, we don't have to change the appearance, and most of what you're looking at can continue to be preserved.
Thank you. Anything else? Appreciate it, guys. At this point, I'll call on the public. If there's anyone present in the public that would wish to support this application, please feel free to come on up. Seeing none, anyone opposed? Okay, I'm not seeing anyone wishing to speak in opposition. So with that said, I will close the public hearing at this time. The board will begin deliberation. Beginning with number 1, that granting the variance would not be contrary to public interest. Who wants to begin? Attorney Taylor?
Thank you, Mr. Chair. I don't believe this will be contrary to the public interest so long as we can figure out the conditions to attach to it, especially since it will be contained within the building and there doesn't appear to be any intent to alter it structurally. It would be simply a continuing use.
Great. On to number 2. If the variance were granted, the spirit of the ordinance would be observed. Attorney Hoppick?
This is a proposed use that, like the other one, is consistent with the essential character of the neighborhood, wouldn't do anything to alter it. And it sounds like Mr. Coughlin is just trying to keep his tenants, the space filled with viable businesses, which also serves the public interest. I don't see that as a threat to the public health, safety, or welfare of the area or the community, so I think those criteria are satisfied.
Great. Number 3, granting the variance would do substantial justice. Anyone? Attorney Taylor?
Thank you, Mr. Chair. I don't see that there is any, any harm to the public under this criteria. Certainly, from the mere fact that apparently it's been happening without any disruption or public notice, I think that goes in to support this, that there's no harm to the public.
I would agree. Number 4, variance granted, the value of surrounding property would not be diminished. Real quickly, I just think that we've touched upon it not impacting the exterior of the property, and no impact to the interior of the property, a use that allegedly is already occurring. So I'm thinking it won't, it's a wash. I don't think it's going to have a positive impact on values, but it doesn't have to. It just can't have a negative one. So
Right.
I don't believe that it does. Anyone else? Number 5, unnecessary hardship. Owing to special condition of the property that distinguished from other properties in the area, denial of variance would result in unnecessary hardship because no fair and substantial relationship exists between general public purpose of the ordinance provision and the specific application of that provision to the property, and that the proposed use is a reasonable one. Attorney Hoppett?
I guess I'll give this a shot. I agree with our predecessor board from 1984 that the size of the building could certainly be a special condition then and now, especially when you're looking at ways to fill up space to lease it. And it is true, in my line of work, I have to deal with counselors occasionally, and most of them, if not uniformly across the board, are remote. Some of them are reluctantly going back to in-person, but you know, it's up to each individual. And to the extent that these people can work from home by video, they're saving a ton of overhead, and they don't need to worry about paying somebody like Mr. Coughlin rent, which is his problem now. So I think that what he's come upon here is a reasonable way to try to fill space and keep his property the way it is and maintain it and let it continue to exist the way it's been for all this time. So I have no trouble with identifying the size of the building as a special condition and then saying that there would be no fair and substantial relationship existing between the general public purpose of restricting professionals in that building as it is applied to this property. So I think it passes that test to justify an unnecessary hardship.
Attorney Taylor?
I agree with Attorney Hoppick, and actually the concept of a building providing its own special conditions, so to speak, was, not to get all wonky on you, but the Farrar versus Keene,
I seem to recall
Case.
that case.
yeah, which basically is the
Right.
basic case that said a building can by itself be a special condition. So I agree with you. I do think there is some concern, though, that the conditions be carefully outlined.
I agree. I think covering all these criteria and supporting them is, of course, directly correlated to conditioning it. I don't think that it can just be a.
Can we take a moment just to have a conversation about those conditions? 'Cause I just have,
Yeah, I think we should, and
Yeah,
we
'cause-
also need to discuss, Mr. Rogers brings up a valid point, that it doesn't need to be understood that while the board can condition these things, as we actually see here in this property, it was happening and we didn't know about it, so actually governing these things is next to impossible. But with that said, we'll put our best foot forward on some conditions that work for everyone and just hope that they're followed.
and that's, part of, I guess, the honor system, I suppose. We're being told, we don't go out and verify what we're being told here normally. People come here and tell us what their plans are. They're in good faith. We take them at their word on the honor system. And if we impose conditions, I'm not too concerned about them being enforced down the road. I think the people, when they leave here, understand what they are, and they will do their best to follow them, so.
And I think no news is good news. If there's an issue, city staff will find out about it, and if there isn't, then
They'll sniff
they
it
must
out.
be coming close enough to the conditions, so, yeah. Go ahead, Joe, what do you want to say about the conditions?
Well, I was going to go with the three that Mr. Fippert suggested, but then Attorney Taylor mentioned something about the sole proprietorship, and that being a little bit ambiguous. I would change that to an individual without employees or something to that effect, who schedules appointments only, no walk-ins, and they're licensed by the state. I think that's pretty clear. That's black and white. If you have a license to do whatever you're doing, you have it, you can produce it. So those are the three that I would, I'm not quite sure if we really need to do anything with those three parking spaces in the back. I'm of a mixed mind about that, and I don't want to make this more difficult for John's office later. But, I guess if it ain't broke, don't fix it. It doesn't seem to me to be broke.
Attorney Taylor?
Yeah, on the parking, I guess I'm concerned because it's just the flat-out no parking, and they're clearly identified parking spaces. So, I'd like to see maybe some limitation on the parking on the north side of the building. be reserved to the building owner, or some sort of language, I'm not quite sure what. I haven't thought it through entirely, but just so that it's not,
I wonder if there's
Customer
some
parking.
merit to make it so that it is for not necessarily the owner, but occupants of the building. So it could perhaps be used for professionals that are renting there, or Mr. Coughlin himself. Go ahead, John.
Thank you, Mr. Chair. I would, that was going to be my recommendation, that it be limited to, occupants of the building. I think the concern might have come before because, as Mr. Fippert said, that driveway leads to, there's a single-family home right next to this property. So I think if it was for customers coming and going, that would generate quite a bit of traffic right next to that single-family home. But if it was an occupant of the building, they're probably going to come in at 8 o'clock and work and leave at 5, and it would certainly cut down. So I think a restriction that it'd be for just occupants of the building would be an appropriate condition.
okay.
Everyone agree with that for the most part? Not for clients, rather
Yeah.
for occupants only. Okay. Any other comments about the criteria?
I guess the one question I would have for Mr. Hoppick would be, you limit it to an individual or individual plus one employee, or, I mean, I guess, I don't know how else to limit it. Clearly, the intent is not to have the crowd.
Yeah.
How many spaces are we talking about there?
Can I reopen the public hearing for 1 second? Go ahead, Mr. Fippert.
There are 7 office spaces.
So if we limited it to an individual plus one employee, we're bumping up against the parking problems, aren't we?
Yeah. John?
Thank you, Mr. Chair. Just a possible recommendation would be that it be limited to, especially if it's going to be a licensed type profession. Most of these licensed professions have a workstation, I guess would be a best term I can think of off the top of my head. Hairdresser would have, the one chair. Some of these other ones that Mr. Fippert's mentioned, I would imagine they have basically a workstation. So if it's limited to one workstation per, maybe that might be a way. Because I would agree, I think the 2 employee, you might be having some more of a higher impact than in this low-density district than the board is intending to.
Since the public hearing's open, Mr. Fippert, do you have any commentary on this?
John?
No, I think I'm in the building also. I've been in the building for 38 years. So I've watched the parking because, I'm using the building also. It's going to be low intense, which it is. It'll be appointment only. The appointments run for an hour to 2 hours apiece. It was not like, people come in every 20 minutes. So I police it myself. So I'm there every day. I'm watching the building. I know who's coming in. So I've done a pretty good job. We've been there for 34 years, 36 years. And I think this will be better because before, with the therapists, there was like 10 of them, and they all had appointments. It was a lot of traffic. This here, it's like I said, appointment only. There's not that many people doing it, and it's a lot less traffic.
Great.
So I
Thank you.
think that's.
Attorney Hoppick.
So can we limit each unit to one individual personal service provider? Would that be one way to characterize it instead of saying sole proprietor or whatever?
I guess our question is, Mr. Coughlin,
That's what you have.
and keep in mind that we understand you police the parking and do a wonderful job, and you do a great job with that building. There's no denying that, but this variance will go on with this property long after you don't have it anymore, so we need to try and come up with something that fits the needs of the community, but also fits the needs for you to keep the building running well. Are you in situations where people have one employee plus themselves, or what would your preference be in terms of employee limit per office?
It would be nice to allow one employee. Certainly, as an attorney, you may have an assistant or a secretary to answer the phone. I have an employee, if I'm out of the office, they'll answer the phone and help take care of my business. But it doesn't generate more business. It's mostly just an accommodation. So I think the ability to have an employee and still lease the space would be beneficial, but probably not mandatory. If you look at the users in the building today, it's all single-person users.
And they have answering machines, and they have things of that nature that,
And they can do
Reduce the need
email, right, to monitor what's coming in. and-
Right.
Great. Any other questions before I close the public hearing? Thank you, guys. Public hearing's closed again. So what are our thoughts on that? I think 7 offices, if everyone had an employee, if you count the spaces, you have a potential problem there. I also
agree.
think that limiting it to one person, may not be the perfect business model for everyone, but I'm fairly certain behind the scenes they'll make that work. Again, I don't even know that we could police how many employees they have, so we're getting down to some things that we probably can't control. Attorney Taylor?
Yeah, it seems to me that the original variance regarding professional offices only stays intact. And that what we are doing is adding to that professional offices only a category of personal services. And if that is correct, that this original variance stays intact, that's why I wanted to clarify the parking, because it's ambiguous. So if that stays intact, I don't have a concern with limiting specifically just the personal services aspect of that. I don't know how others feel.
What do you think, Joe?
I think we can condition approval on one individual working in one, per unit, who does it by appointment only and is licensed by the state for their particular personal service, whatever it may be. And we're talking about an esthetician, I guess, in this case. And
That
then
sounded like a motion.
if I can repeat it, if I don't have to repeat it, I'll be happy with letting the record stand. But then we want to deal with the parking.
North side parking to be used for tenants only.
Building occupants
tenants.
only? Okay. So, all right, let's try that then. I forgot what number this was. I move to approve 2207, subject to the following conditions. The personal service uses shall be restricted to one professional personal service provider per unit who schedules by appointment only and is licensed by the state for their particular profession or personal service. And that the parking on the north side of the building be restricted to occupants of the building. And that's it.
All right, second. We have a motion from Attorney Hoppick, a second from Attorney Taylor. So, at this time, we'll hold a vote, beginning with number 1, that granting the variance not be contrary to public interest. All in favor? It's unanimous. Number 2, if the variance are granted, the spirit of the ordinance would be observed. All in favor? It's unanimous. Number 3, granting the variance to do substantial justice. All in favor? Again, unanimous. Number 4, if the variance are granted, the value surrounding property would not be diminished. All in favor? Again, unanimous. And number 5, relating to unnecessary hardship. 5A, that owing to special conditions of property that distinguish from other properties in the area, denial of variance would result in unnecessary hardship because no fair and substantial relationship exists between general public purpose of the ordinance provision and the specific application of that provision of the property, and that the proposed use is a reasonable one. All in favor? It's unanimous. All of those in favor of ZBA 2207 with conditions, it is unanimous. Thank you. At this point, we will move on to the next one.
Thank you.
Thank you. Have a good evening. I am going to call for a quick 2-minute break before we start off ZBA 2208.
And then if they have questions, I'll come up, or is it? Okay, perfect, okay.
You're after us. All we want to do is put in the pool. So, but if you buy any pool and you're going to the target for about 20 minutes, it's fine.
Welcome back from vacation.
I forgot about it, and then I was looking through my phone. I'm like, oh, CBA on Monday.
Yeah, I know.
It's all right.
I don't know. I don't even know if we're there yet.
A rainy Monday.
Yeah.
You guys staying very busy?
Yes.
Every time I talk with those guys, it seems like they're very busy.
Yes. And it's not just one office either. It seems to be like
Across the board.
across the entire company, which is great.